Further hearing the appeal, Commissioners for Her Majesty's Revenue and Customs against NCL Investments Limited and another.
Yes, it's more.
My Lords, my Lady, with your permission, I propose to deal with the accounting arguments and then section 1290. The accounting arguments I'll deal with in this order. A few points about the transaction and the accounting. Then what my learned friend described as the big picture point. Does the rider to section 46 leave space alongside Parliament and the accountants for judges to get involved? Then the incurred question, the purposes question, the capital question, and if I have time, a little bit of mopping up. And then I'll get on to 1290. So, dealing first of all with the transaction and the accounting treatment, a few points. Firstly, there's a finding of fact that the appellants agreed to pay the holding company for the share options. And that's at para 13, first sentence, EF 177. Second point, at a group level, the options are regarded as forming part of the remuneration package of the employees. That's para 15, final two sentences. And the appellant's object in paying the recharge was to benefit their trade by paying for the grant of the share options. That's para 17, final sentence, EF 178. Third point, there is a capital contribution on the grant of the options, but it immediately reverses out because the appellants have agreed to pay for the options, and that's paras 33 to 35 of the FTT, electronic file 183 to 184. And I interpose, in a sense, the capital contribution is an accounting fiction because it immediately reverses out. And there's a finding that it doesn't survive until the balance sheet date, until the end of the accounting period. Fourth point, you have the finding of the FTT at paras 9 and 13, EF 175 and 177, that the cost of the options plus the margin charged by the appellants formed part of the revenues of the appellants. Fifth point, the debits that arise on the grant of the options are not consumed on receipt. They are consumed over time as the employees continue to provide their services. And the finding to that effect is FTT para 28, electronic file 182. And then the final point, 6. As to what IFRS 2 is for, there's a finding at para 29 of the FTT that the rationale of IFRS 2 was that appellants were consuming the services of employees. But it might be helpful just to look at the financial reporting standard itself. The very first paragraphs of the introduction you find at electronic file 287. So if you read IN1 and IN2, you see that they talk about how to recognise employee remuneration arrangements involving shares and share options. And then the very first paragraph of the objective of the IFRS, you find at at EF 290. That's para 1 objective. And you'll note that it talks about reflecting in the profit and loss account of entities the effects of share-based payment transactions, including expenses associated with transactions in which share options are granted to employees. So some submissions on those points of fact. First submission. In the generality, share options are an important part, sometimes even the entirety, of the remuneration package of an employee. If you ignore them in the calculation of your accounting profits, you overstate your profits because you have understated your costs. You have failed to take into account part of the costs of earning those profits. I advance that as a matter of submission, but you can see it, in fact, in the basis of conclusions document. I don't propose to take you to it, but for your note, it's in BC 38 at EF 329 and BC 60 at EF 333. Now, I made that point as a point of generality, but it's especially clearly true in the case of these appellants, because the sum that the appellants pay for the share options plus a margin is part of the revenue of the appellants, and the sums they pay for them, excluding the margin, are part of the appellant's cost base. So to ignore those debits in the calculation of the taxable profits of the appellants, or indeed the accounting profits of the appellants, leads to a distortion, an inflation, a non-commercial calculation of the appellant's profits. Obviously, I say, as a matter of submission, that's a conclusion the court should be slow to reach. Next point. I just don't understand what my learned friends say about IFRS 2 being about your balance sheet and not about your P&L. I don't understand where that proposition comes from. I don't understand what its foundation is, and I don't see anything in the IFRS that justifies it, and nor do I see a finding of fact to that effect. Next point. Even if I were wrong about this, and IFRS 2 was, as my learned friends submit, mainly about balance sheet entries, how is the court supposed to work out what accounting mandated debits it can take into account and what accounting mandated debits it should not take into account? What's the analytical content of the exercise that my learned friends invite you to embark upon? I'll come back to that proposition, if I may, under my next heading. I also, next point, don't understand my learned friend's presentation of the facts of this case as being about options which just happen to the appellants. They agree, there are findings of fact, to pay for those share options. They agree because they intend to incentivize their employees. They could have brought health insurance, they could have leased cars, they could have provided gym membership. They pay for share options. And then the final point before I leave this heading. In fact, I was about to repeat myself. I won't make that point. So I say, standing back, the conclusion that each of the courts below arrive at, namely that this is a debit that is properly taken into account in the calculation of the taxable profits of the appellants, is entirely unremarkable. And in fact, I go beyond that. I say that the proposition for which my learned friends contend is a remarkable proposition. So that's all I wanted to say under the first heading, subheading of my accounting arguments heading. Second heading, the big picture point: does the rider to section 46 leave space alongside Parliament and accountants for judges to get involved? There was some discussion yesterday between the bench and my learned friend about William Grant. I say that William Grant does accurately state the law. The paragraphs that were put to my learned friend were Lord Hoffman, first and second paragraph of his opinion, and paragraph 38 of Lord Hope, and the file references are 1022 and 1029 respectively. I just want to draw out two points of detail from those paragraphs. The first point of detail is that the formulation that Lord Hoffman cites is Odeon-associated theatres, and I will come back in a second to discuss Odeon in a little bit more detail. I say Odeon is the best articulation of the rule and of the reasons for the rule. And then the second point I want to make is that I just want to observe that Lord Hope says at para 38, it has to be recognised that accounting standards have moved on. I'm going to make some submissions as to what that means in the world that confronts the Supreme Court today. So The passage in Odeon Associated Theatres you find at electronic file 873. If I could invite you to turn that up. And if I could invite you to read the 3 paragraphs, starting with a paragraph beginning the expression ordinary principles of commercial accountancy. And the point I want to emphasise in particular is in the paragraph beginning, Mr. Watson said, it's not clear to me precisely what standard the court should adopt. And of course, judges are clever people, but what do they bring to the party that accountants do not? What role do they play when accountants are the experts in the calculation of taxable profits? Experts in the calculation of accounting profits, and where Parliament has spoken as to when and how accounting profits should be adjusted. And I say that that's the point that's being made in that passage in Odeon Associated Theatres, that it's all very well to contend for the existence of a judicial power to get involved alongside the accountants and Parliament. But how are you supposed to do it? What is it in your particular expertise as lawyers that enables you to supplement the work of accountants and Parliament? There's a related point as well. Lord Reid put to my learned friend yesterday that although we're no longer in a world in which taxpayers are only charged to tax by the clear words of a statute, a proposition with which I agree, my learned friend's case takes one really quite a long way away from that world, and I say too far. You're not in a world in which taxpayers can only be taxed on clear words, but taxpayers are entitled to some certainty about what their tax liability is. It's striking to me that my learned friend did not, in his submissions yesterday, define any proposition of law that he says that the tailpiece to Section 46 permits. And it's no part of his case, as I understand it, that the intervention he invites you to make is the only intervention that a court might make. In other words, if you throw open, I fear I'm going to regret this metaphor, if you throw open the stable doors to let out this horse, what other horses follow it? Odeon was approved in Gallagher and Jones and Johnson and Britannia. And my learned friend yesterday directed you to a sentence in the judgment of the Master of the Rolls, Sir Thomas Bingham, in Gallagher and Jones. But it's also fair to note that the Master of the Rolls adopted the formulation in Odeon, as did Lord Justice Nolan, and the references for that are 528 and 533. And I just want to pick up now the second point that I foreshadowed in my brief discussion of William Grant. I said that I pointed to Lord Hope's statement that it has to be recognised that accounting standards have moved on. What's the point that I'm trying to make there? In my respectful submission, what you see in Gallagher and Jones and a lot of the older cases too, like Lowry and Anaconda and Sharkey and Werner, is courts addressing a world in which accounting practices were not settled. And what you see in those cases, in my respectful submission, is that which would now be a matter of expert evidence being treated as a matter of common law proposition of law. So you contend for the existence of a rule of law in substitution for accounting evidence which can't be given for any degree of certainty. That was the world in which Anaconda and Lowry and Sharkey and Werner were decided. Gallagher and Jones is an interim world. But I do say that it's worth noting that both the Master of the Rolls and Lord Justice Nolan adopt the formulation in Odeon, which I say is the right formulation. Just turning next to the language that the drafter uses in section 46. And I accept my learned friend's point that as a matter of literal construction, adjustment required or authorised by law could include judge-made law. But I do say that if Parliament had intended to change the law from that stated in Odeon, it would have said so.
I mean, the interesting thing, it strikes me, about reading Odeon is that there the Master, the Vice Chancellor, yes, the Vice Chancellor, is treating the scope of the court's ability to adjust the figure produced by proper accounting principles as very limited, as limited to what is expressly required by statute.
Yes.
Which is what Lord Hoffman then also says subsequently. The Vice-Chancellor is treating the court as having a role in relation to determining what the proper accounting principles actually are.
Yes.
And really, the import of William Grant is to make it clear that where there are settled accounting standards, those are the principles that the court should be applying. As I read it.
My Lord, yes, I adopt those points as my submissions. I say that's exactly right, and both myself and my learned friend say that the pre-consolidation case law was codified, if you like, in the 1998 Act. We just disagree about what the effect was of the pre-consolidation case law. I say that it was as stated in Odeon. My learned friend says, no, it's a much wider mandate for judges to find common law rules, adjusting the practice adopted, the settled practice adopted by accountants.
Yes. I mean, one sees it particularly in the Vice-Chancellor at, in the electronic file, it's page 873, in the paragraph before the one you took us to, beginning Mr. Watson, the preceding paragraph, beginning the expression, tells us that the effect of the principles laid down in the earlier cases is that first you ascertain the profits in accordance with ordinary principles of commercial accountancy. Secondly, one must adjust this account by reference to the express prohibitions contained in the relevant statute. And in principle, there could be not just express prohibitions, there could also be other provisions in statutes which required an adjustment.
Or permit an adjustment, Lord Sales' point from yesterday.
Yes, authorised, yes. Yeah.
Might a potentially wider example be if the accountancy profession adopted as a standard, or an expert witness gave evidence that, as it were, ignored a prior decision, let's say, of the House of Lords on a point of principle which Parliament hadn't in any way subsequently departed from, so that one might say that there was a rule of law with which the apparent accountancy principle didn't appear to be compliant.
Well, I say to that...
I'm not suggesting that's this case, but I'm just looking to see what the four corners of the tailpiece really are.
Yes. So, I was about to say that isn't our case. The other point I was going to make was Sharkey and Werner. So Sharkey and Werner is a case where there is a judge-made rule that predates the enactment of accounting practice in 1998, which finds statutory expression after 1998. My learned friend says that it applied in the interim. It was applied by everyone in the interim, and my learned friend is much more experienced in these matters than I am, and I'm sure he's right about that. But that's not to say that the profession was right to do that. What you would want in my respectful submission, is a finding that post-Finance Act 1998, Sharkey and Werner, a judge-made rule, contrary, according to the explanatory note, to ordinary principles of commercial accountancy, remained good law. And I don't think there is an authority for that proposition.
It seemed to me, I was looking at Sharkey and Werner and the explanatory notes for, I think it was the 2008 Act. Sharkey and Werner was 1956. I think I tried to put it to Mr. Ghosh that it was dealing with a case where there was a gap in GAP. I mean, GAP probably didn't exist in 1956, but an aspect of treatment of particular items for accounts which hadn't been settled by accounting principles at that time. And what seems to have happened in the House of Lords in Sharkey and Werner is because it wasn't settled by accounting principles, the House of Lords laid down the rule as a proposition of law. So what then happens after that is that there is a development in the accounting principles which come to depart from that rule of law. But it's been stated by the House of Lords, so it's still a rule of law that everyone continues to apply. And indeed, they're probably right to apply it, because that would be consistent with the guidance in Odeon, because here are accounting principles, but there's a contrary rule of law, and you follow the law if there's a conflict. And then in 2008, Parliament confirms by its legislation, yes, we're happy with basically the Sharkey and Werner solution. And so what was, if you like, a judge-made rule of law, although applying the previous statutory rules in relation to the tax law, is confirmed by Parliament in 2008, no matter what current gap was at that time.
Yes. And no doubt all of that is true. The point that I'm making, I was attempting to make to Lord Briggs, is you don't know whether the House of Lords made rule of law continues to be good law post the Finance Act 1998. It may be that the statutory prioritisation of accounting principles displaces the House of Lords' decision in Sharkey and Werner.
But, I mean, in a sense, that explains why Parliament revisits it in 2008. I mean, one can infer that perhaps that uncertainty had grown up, and yeah, one can see that you could debate it either way. Either, no, it's a rule of law, Parliament hasn't displaced it, and compliance with Werner and Sharkey is actually an application of the principle in Odeon, or people saying, oh no, it's been displaced, and so that uncertainty is laid to rest in 2008.
Yeah.
Yes, but I mean, I entirely accept that, and I would put that aspect of Sharkey and Werner in my basket of authorities that transition from a world in which this was all a matter of submissions to a world in which it's all a matter of evidence. But what I do urge upon the court is that one mustn't, in my respectful submission, reintroduce the uncertainty that accounting standards are all about removing.
I mean, Odeon itself is laying down a principle of law.
Yes.
A principle of law that you apply commercial accounting standards. And no doubt you can find in the law reports umpteen judicial statements about how profits should be calculated and what should and shouldn't be taken into account. The point of the statute is there's now a statutory rule which requires you to apply to compute the profits in accordance with generally accepted accounting practice. and then it's subject to a rider, which, well, certainly in the Odeon case, was concerned with the impact of any contrary legislative rule.
Yes.
And that's, I mean, it's pretty strongly affirmed, I'd have thought, by Lord Hoffman and Lord Hope's golden rule in the Grant case.
Yes. I mean, I have to say, in giving my time estimate, to me the points are clear. They really don't admit of doubt, in my respectful submission. One can also make a very similar point by reference to section 48.
I mean, to take it at its bluntest, if it's a House of Lords decision that's from 1928, say, that says in computing the profits of a company, you ignore X. If nowadays, in accordance with generally accepted accounting practice, you would take into account X, then the statute trumps the House of Lords.
Yes. I mean, I don't need to go so far as to say this case is a bad law. I just say that the law has changed. And in fact, I don't have the difficulty that my learned friend has with Lowry. I don't see the tension I see in Lowry. The House of Lords struggling to answer the question, which is the question you're answering about what are the correct principles of commercial accountancy. They just have to do it without any evidence, and because they're lawyers, not accountants, with respect, they can't do it as well because it's not what they're trained to do. Section 48, you find it EF 362. Now, at this stage in the argument, we're still talking about the existence of a general principle, but we're talking about it in the context of a transaction that my learned friends characterise as not involving any economic outflow. And my learned friends make the point, and the Court of Appeal emphasises this point as well, and it's the point that's right, that Section 48 is a definitional provision. It defines expenses. It doesn't create a general rule that one always ignores outflows of resources. Expenses is language that you'll see when we get to the incurred provision. In section 46, is it? No.
54.
Forgive me, section 54, I'm grateful. So I take my learned friend's point that it's a definitional provision. Nevertheless, it would be odd to have both that definitional provision and a judge-made rule that there needs to be an economic outflow. Because the import of section 48 is that there doesn't need to be an economic outflow.
Well, an actual receipt or a payment.
Receipt or a payment, yes.
It might be an economic outflow, but not an actual receipt or payment.
I take the Lord's point. I don't think I need to make any further points under this banner. So then let me look at the incurred argument. And the argument, as I understand it, is that because there was no cost, the debit wasn't incurred. That's the way in which it's put it. Malone and Friends' written case at para 65. And I say to that proposition 4 things. Firstly, it's impossible to square it with section 48. I've just shown you that under a different heading, which says that it does not matter whether an amount has been paid. Expenses in section 54 means accounting debits. Second point, there was a cost here. In the case that you are deciding, there is a recharge. These appellants did agree to pay for these share options, and they agreed to pay for them because they saw them as being part of how they wanted to remunerate their employees. Malone and Friends says, rightly, that the debit isn't in respect of the payment, but that's very often true. It's inherent in an accrual system of accounting that accounting debits are very often for things different than economic outflows. They simply recognise here that there has been a consumption of services, or in cases like Jenner, that it's proper accounting practice to take a provision. And I say respectfully that to require one to ignore the recharge is to live in the sort of unreal, one-eye open world that the taxpayer was very often criticised for, including in cases like UBS AG. It is awkward to have to close one's eyes to the fact that the appellants agree to pay for the share options when you're considering whether an expense has been incurred. Third point, this is a provision about how you deal with expenditure with a dual purpose. You can see that in the heading to section.
Could I just pick you up on that? I mean, the accounting principles say that the debit is to be applied whether or not the recharge is paid. So, for all that you say, well, we should look at the reality, at some level, isn't that somewhat in tension with the argument you've been presenting that we should just be looking at the accounting principles? So, suppose one was dealing with a company which hadn't paid the recharge.
Yes, and I understand there to be follower cases where there is no recharge, and that was the point Malone and Friends made to you yesterday. Yes. But even then, when you recognise a provision for future expenditure in your accounts, the Jenner case, there is no in-period outflow of resources, and there is no certainty of outflow of resources. I mean, obviously I accept the point that here, if you ignore the recharge, there is no possibility of an outflow of resources. But ultimately, you then get back to the point that I made earlier, that it is uncomfortable not to have before the court a formulation of the proposition of law that my learned friend says that the tailpiece to section 46 enables this court to find.
Yes, well, I think that's why I was putting to you that your latest point seemed to be in tension with your previous submission, that we should just go with the accounting principles.
Yes, that's my best point. Yes.
But in this case, the recharge is in fact accounted for as a payment for a capital contribution, isn't it? That's how the recharge, as I understand it, is actually dealt with in the accounts. So that the capital contribution is reversed out by virtue of the recharge.
The capital contribution is reversed out by the recharge, yes. I mean, that is certainly true. But you also have to look at why there is a capital contribution in the first place. Yes. There's a capital contribution in the first place, despite the fact that it's immediately going to be repaid by a balancing recognition of an obligation to repay the capital contribution, just because of what I described earlier as an accounting fiction. The reality is that these companies are never going to have a capital contribution because they have agreed to pay for the share options. You can see that the FTT wrestles with this very question. I think it's in para 33 of its decision. It says, you may wonder why you recognise this transaction as a capital contribution. And indeed, I did wonder why, and I'm still not sure I entirely understand it. But to say that all that the recharge does is reverse the capital contribution, in my respectful submission, only looks at part of the story. You have to look at the full story, and the full story is that the capital contribution itself only arises because the companies, the appellants, have agreed to buy share options from their parent. But for that, you wouldn't have a capital contribution to be reversed out by the recharge.
The oddity is that the recharge and the debit that we're talking about are not alternatives, that the debit has to be included in the P&L account, even if there is a recharge.
Yes, I accept that. And that's undoubtedly true. My primary case is this is a case where you have a recharge and you're not deciding another case. My secondary case is even if you ignore the recharge, I remain right because that's what the statute says. The statute says that you have to take into account accounting debits, save where Parliament tells you otherwise. And I've explained in my initial remarks about the transaction and the accounting why to do otherwise is to ignore part of the cost base of a taxpayer that chooses to pay its staff in part with share options. And so to ignore those accounting debits is to distort the calculation of the profits of that taxpayer.
I wouldn't pretend that I fully understand the accounting logic, but I suppose you could also say that the accounting standard is there because in this sort of situation, the accountants are concerned not just about the accounts of the appellant companies showing a true and fair view, but also the accounts of the parent company showing a true and fair view. And so there needs to be some way in which both sets of financial statements can achieve a true and fair view, and they marry up together.
Well, except for, I mean, that of course is true. I would add that in the accounts of the parent, the investment and subsidiary is also reversed by the recharge. And I'd also add that that IFRS 2 applies not just in respect of the grant of shares and share options by a parent, but also in respect of the grant of share and share options by the entity that takes the debit.
Yes,
So,
but I was thinking more about a case where you don't have a recharge. I mean, the accounts of the parent then presumably would have to show a capital contribution because they're
yes.
providing shares to the employees.
Yes.
But then the employees have done the work, which is the consideration for that for the appellant companies.
Yes.
And somehow the accounting standards have to produce a result which allows both sets of financial statements, i.e. parent and subsidiaries, to show a true and fair view.
My Lord, yes. Below, I said that your focus should be on the quality of the debit, that limited insight into the quality of the debit is obtained by looking at the quality of the matching credit, and even more limited insight into the fiscal quality of the debit, which is what this court is concerned with, is obtained by looking at the matching entities of the holding company. And I do repeat that submission here, but that's not a that doesn't displace the point, my Lord, that you're putting to me. It simply qualifies it. I mean, I adopt it. It is likely to be right.
Yes, thank you.
I don't want to take up too much of my time. May I move on to purposes?
Have you expressed your main point in relation to incur? I thought the real point was that what the taxpayers incur is the deployment round the group of the enhanced service of their employees, actually that little shinier bit of their work caused by the incentivisation.
Certainly
That's what's meant by consumption, isn't it? Why the consumption is said to be the expense.
Well, my main point is that incurred means accounting debit, and the accountants say there is an accounting debit, and that is an end of the matter. But I do make that point against the background of these particular debits being for the services of employees who are employed by a group employer company and whose services are charged to other group companies, and so are very clearly part of the profit-making apparatus of the appellant companies. So, my Lord, I say that the way in which your Lordship puts it to me is right, but the short way home, and in my respect for the right way home, is to say that the accountants say it's a debit, and that's it.
End of case. Yeah, I understand.
The point about it delivering the right result, leaving aside the accounting treatment, is a bit of a jury point. But it's one that should make you comfortable with the submission. Purposes. My learned friend's case is that the debits don't have any purposes at all, and so they can't be incurred wholly and exclusively for the purposes of the trade. And the argument begins with the proposition that the companies weren't party to the transactions. You can see that at my learned friend's written case at para 71. But in my introductory remarks, I pointed out that that starting predicate is just not made out on the facts as found by the first tier tribunal. the appellants were party to these transactions. They agreed to pay for the options, and they agreed to pay for the options because they wanted the options to incentivise.
When you say they agreed to pay for the options, what is it that you're identifying as the payment?
The recharge is the payment.
That's what I thought you were going to say.
Would it help, my lady, if I gave you the paragraph references in the
No, I just wanted to be clear that that's what you were saying when you were talking about them agreeing to pay for the options.
It depends, as I put it to Lord Briggs a couple of moments ago, where you start the story. If you start the story with the grant of the options, then perhaps my learned friend's point is a better point than it is here. But I say that the options aren't granted to the appellants unless the appellants agree to pay for them, and that's what the FTT has found. And so I say that you start the story with the appellants agreeing to pay for the options, otherwise the options aren't granted.
I mean, I suppose it might be said that the appellant company's involvement goes a bit beyond that, because it's probably an implied term of the contracts of employment that they give the employees the opportunity of working in order to earn the options which are being provided to them. I mean, it's part of the remuneration. An employer has to give their employee a fair opportunity to earn the remuneration which is put on offer to them.
Yes.
I'm not sure it affects things very much, but
there was no discussion at the FTT about whether there was an implied term there was no express term in the contracts of the employees that they had an entitlement to share options. There was no discussion in the FTT about whether there was an implied term to that effect.
Yes.
But remembering when I did employment law very briefly in my pupillage days, sometimes you do find implied terms of the nature put to me by my Lord Sales. So I say that my learned friend's argument starts in the wrong place. But I also say, I also rely on the point best made by the Court of Appeal at paras 54 and 55. I don't think you need to turn it up, it's at electronic file 140. That the purpose of recording a debit is always to comply with one's obligations under company law to keep proper accounting records. And the law cannot be that you cannot lift your head from what is in your mind as you apply your quill to the vellum and note your journal entry. You have to look at the relevant facts in order to discover the purpose. What is the purpose of the transaction that is being recorded in the journal entry? And when it comes to the purpose of the transaction, I say that the findings of fact by the first-tier tribunal are unimpeachable. Then on capital...
And just on that, presumably it is just a finding of fact. I mean, purpose is a finding of fact. You've got the finding of fact in your favour.
Yes.
It would be for the revenue to show that was a perverse finding before we could go behind it. Isn't
Yes.
that right?
That is what I would say, yes. Dealing finally with my learned friend's submission on capital, the statutory provision of section 53, it's at EF 364, no deduction is allowed for items of a capital nature. But the short point is, this isn't expenditure of a capital nature. The debit isn't expenditure of a capital nature, it's expenditure of a revenue nature. And you have a finding of the FTT at paragraph 22 to that effect. For reasons I've never entirely understood, findings as to whether an item is on revenue or capital account are findings of law, not of fact, albeit, if I recall correctly, there's dicta that you should be slow to overturn an accountant's view as to what is revenue and what is capital. But that's not really what my learned friend's inviting you to do. My learned friend is emphasising the fact that the contra entry is investment on capital account, and that somehow tells you something about the quality of the debit. But I say the quality of the contra entry tells you nothing about the quality of the debit, which is for expenditure of a revenue nature. It's to remunerate employees. It's an absolute paradigm revenue transaction. The question is not, putting it another way, the question is not how did the companies fund the debit, but what is the debit for? No deduction is allowed for items of a capital nature. What is the debit for? Is it for capital or is it for revenue? My respectful submission, it's clearly for revenue, and the quality of the contra entry is irrelevant.
And presumably on that it would be like a startup which is funded just by share issue, so capital, but paying the wages of the staff out of those resources.
Well, that's an example that, in fact, very much like an example I give in my written case. I say that if you fund wages with capital, that doesn't make them any less wages on revenue account.
Just in case, just going back to what you were saying about the nature of a finding whether an item is revenue or capital, you said there is some authority that says that's law, not fact.
Yes.
At some point, could you perhaps just, perhaps with agreement with Mr. Ghosh, if possible, just send us through a note of that? It probably doesn't matter at all, but just so that we've got that information in case.
My Lord, I'm grateful for your kindness in not pushing me for the authority now.
No, well,
but we'll certainly
don't have it in mind.
We'll certainly send. I don't anticipate it'll be a matter of disagreement between myself and my learned friends.
But if it is, even if it is a question of law, if it's been included in the profit and loss account, then doesn't section 4648 resolve the question?
No, there is still, in my respectful submission of statute, there is still a question. It is open. So I think where we get to is this. The fact that the FTT has found that the transaction is on revenue account, not on capital account, is not a finding that can only be interfered with if you found that it was perverse. You could interfere with it if you found that it was wrong as a matter of law, but it's not wrong as a matter of law, it's right as a matter of law for the reasons that I've given, and indeed for the reasons that the FTT gave.
I rather understood my Lord's question to be to that effect. If the law, section 46 and section 48, says you treat things in the accounts in accordance with accounting principles, isn't that a rule of law that directs you to treat this as a revenue item, because that's what accounting principles say you should do?
With respect to my learned friend's clients, I mean, I hear the force of the point my Lord is putting to me. It may well be right. I have never understood why the capital income distinction is a matter of law rather than a matter of fact, but it probably is a proposition that deserves fuller argument than the Supreme Court's going to get today.
But are there expenses which are treated, which are required by accounting standards to be included in the P&L account, which are nonetheless capital expenses for the purpose of computing corporation tax?
That seems to be the effect, I agree with Milady, of what I understand to be the common law rule that a finding of capital or income is a finding of law, not a finding of fact.
Right.
You are, I hope, you are probably correctly hearing me struggle with whether that proposition of law is right, and whether it is right in a post codification of accounting standards world. But I hope Milady also hears me explain why, given the importance of that rule to tax law, I'm resisting the temptation to make that submission. So that's all that I had under that heading, save for mopping up. I think the only point in my mopping up section that I hadn't covered was ingenious. And perhaps I need to no more than adopt what the Court of Appeal has said. Well, so the Court of Appeal's findings at para 49 are that ingenious in the upper tribunal on this point was doubly obiter. But in fact, the key point is the point, in my respectful submission, the key point is the point made at para 448 of ingenious at EF 666. It might just be worth turning that up. So it's electronic file 666. Para 448, first sentence. And in my respectful submission, if you then look at para 449 whilst you're there, and the final sentence of 449. We've therefore considered the question of incurred by reference to the submissions made to us. And the meaning of incurred in a capital allowances context is very different from the meaning of the word incurred in the context of section 54. Incurred in a capital allowances context has a particular statutory definition. That statutory definition is different from the statutory definition in section 54 conditioned by section 48. And there is, and this is the real point, just no read across between the two. And really, I say that the upper tribunal is trying to signal that it's not entirely happy with the submissions that have been made to it in the final sentence of paragraph 449 when it says, I'm only answering the submissions that have been made to us because our view is that there is just no read across or no obvious clear read across because the wording has very different meanings in those two different statutory provisions. And that's the real answer to why Ingenious doesn't take one anywhere. It didn't feature very heavily in my learned friend's submission, so I don't think I need to emphasise it in great detail. 1290. I propose to deal with this, with the Court's permission, in two stages. Firstly, by reference to general observations about 1290, and then looking at the statutory language. General observations first. Section 1288 was at the forefront of my arguments in the Upper Tribunal and the Court of Appeal. My learned friend yesterday jokingly complained about not having been listened to below, and I feel likewise on my submissions about 1288. I say that 1288 is very important context to 1290. Might just be worth opening 1288. It's at EF 368. And you see at 1288, it's headed unpaid remuneration. And remuneration has a special extended meaning. You see at 1288.1, this section applies if an amount is charged in respect of employees' remuneration in a company's accounts for a period. The amount would, apart from the section, be deductible, and remuneration is not paid before the end of the period of 9 months immediately following the end of the period of account. So it's very, very similar territory to 1290. It's designed to achieve a symmetry between the corporation tax deduction and an income tax charge. And if you turn over the page to 1289, you see it sub 4. The purpose of this section and section 1288, remuneration is paid when it would be so treated if it were not exempt income. So it's a point I emphasise in my written case. I say it's a very clear statement of statutory intent in respect of a transaction covered in respect of a transaction like this one, that Parliament does not find offensive an asymmetry that arises by reason of the fact that the income is exempt.
Is exempt income a defined term somewhere? If so, I wouldn't mind a reference to it, but you don't need to take us to it now. It presumably is.
Yes. Before the Upper Tribunal, I handed up a detailed note,
yes.
Which I'm happy to, which deals with definitions of exempt income and shows you how you get from 1289 4B to my proposition that it includes share options, and if this and Milan and Friend has never taken issue with that note, which is why I haven't troubled the court with it. But I'm very happy.
No, I just really wanted it for a
yeah.
cross-reference.
Well, it's sections 8. Section 8 defines exempt income.
That's fine. If that starts a powder trail, I'll just...
And that does, I'm afraid, start a little train.
Yes.
But it is Section 8 that defines exempt income. And whatever the intent of 1290, you have a very clear statement of intent in respect of a transaction like this one in 1289 4B. Now, the history and the purpose of sections 1288 and 1290 are set out in the Dexter case and my learned friend's written case. You spent some time looking at Dexter yesterday, but it might be worth turning it up again, if the court will permit me. It's a loose authority. And at paragraphs 2 and 3 in the judgment of Lord Hoffman, you see a description of when it came in its predecessor form in the 1989 Finance Act and why it came in. Section 4, Section 43 of the 1989 Act was intended to deal with this situation. At section 40, at paragraph 4, you also find section 43 set out, and sub 11 contains the provision with which the House of Lords was confronted, subsection 11, and the question of whether amounts transferred to an EBT are potential emoluments as defined. And at paragraph 7, you find the statement of the issue that is before the House of Lords. The question in this appeal is whether certain payments made by the taxpayer companies to an employee benefit trust were potential emoluments within the meaning of section 4311A. And then at paragraph 18, I invite my lords, my lady, to read that paragraph.
But here, although it was an EBT, the payments were just cash payments.
Well, that's one of the points I'm going to make,
Right.
yes. It wasn't concerned with exempt income. And 1288 in its predecessor form applied to payments that were made to an EBT, cash payments that were made to an EBT. Those are the points that I'm trying to draw out at the moment. And then at the end of para 18, you see another citation of the proposition that the Court of Appeal gives you, that the heading is relevant to the term that is defined is relevant to what the definition means. And then at para 20, this was the paragraph that we focused on yesterday. You probably don't need to look at it again. The taxpayer complains that maybe they'll never get the CT debit. And the answer is, well, that's just what Parliament intended if the sums are never paid out of the EBT in a form that is taxable. So you can, as it were, put that authority away. My learned friend's written case, paras 23 sub 2 to 23 sub 4, electronic file 65, makes the point that section 1290 was a response to his clients losing in the special commissioners. He says it was a response to a fear that section 1288 might not apply adequately to asymmetries arising through the use of intermediaries. Page reference again is EF65, Milady, if useful. So the point that those laborious submissions attempted to provide a foundation for is that it's hard to see how the mischief that section 1290 was trying to address was a situation where the reason there won't be anything coming out in a taxable form is that the income is exempt, i.e. our situation.
Sorry, could you say that sentence again?
The mischief that 1290 was attempting to address was a fear that section 1288 might not be broad enough to catch payments made through an EBT, payments of normal income, if you like, in contradistinction to exempt income. It was not enacted to reverse the parliamentary intention expressed in 1289 4b, because it just has nothing to do with that. The situation in which it was enacted has nothing at all to do with exempt income. And the point's, in my respectful submission, important when you hear what my learned friend said yesterday about the breadth of construction, on his view of the world, of section 1290. My learned friend yesterday said 1290 applies to all share options. He didn't shrink from the proposition put to him by my Lord Reid that it might apply to salaries and bonus schemes. It's likely to apply to deny a CT deduction, not just for exempt income in the form of share options, but also other exempt income too. So at first instance, I gave the example of a carpool scheme. On the learned friend's view of the world, section 1290 denies a whole series of corporation tax deductions when income is exempt and because that income is exempt. Credit to my learned friend, he didn't shrink from that proposition. But the point that I'm putting to the Supreme Court is, if Parliament had wanted symmetry in respect of exempt income and corporation tax deductions, in other words, if it had wanted to deny corporation tax deductions because income was exempt, in respect of an enormous variety of situations, and in the face of section 1289 4b, would it really have done it through this mechanic? My respectful submission, the answer to that is clearly no. I say, ultimately what we're trying to find here is Parliament's intention. Parliament is unlikely to have intended such a striking outcome. If Parliament had intended to rule that you don't get a CT deduction if you're in receipt of exempt, or if you're paying exempt income, it would have said so. It wouldn't have done it through this through the mechanic of the language of section 1290, which is on any view unclear. I say it's on any view unclear because, irrespective of what this court decides, I've won 3 times below, so it must be unclear. And that point that Parliament can't have intended, was unlikely to have intended, to deny a corporation tax deduction on the payment of exempt income, found favour in the first-tier tribunal and the upper tribunal, even without reference to the submission that I advanced, but which did not find favour below, about the importance of section 1289 4b. I say it is a good point. I say it cannot have been Parliament's intention. Of course, I need to make that broad proposition good by reference to the statutory language, and it's to that I now turn. So, section 1290 is asking whether you disallow a deduction. So you're considering the question at the time you take, or but for the disallowance would take, the deduction, not 4 years later at a vesting date, where something else may happen to the property that is comprised in the employee benefit scheme. Because you need to know whether you can claim the debit now or whether the statutory provision disallows it now. So I say you have to answer the question posed by 1290 and 1291 by reference to the facts as they exist today, not by reference to the facts as they exist in the future. Next point, the deduction has to be in respect of employee benefits contributions. So there has to be both an employee benefit contribution and the deduction needs to be in respect of it. So just pause there. What was the deduction here in respect of? I say it's impossible to say that the deduction is in respect of the award of shares, because you get the debit even if there is no award of shares. You get the debit years before an award of shares occurs, if there is an award. The EBT trustees don't acquire shares in consequence of the debit being granted. Findings of fact to that effect. Indeed, there is no relationship on the relevant date between the debit and the shares at all. And still looking at the shares, I make a similar point by reference to the language in section 1291. So 1291 says that you have an employee benefit contribution if, as a result of any act or omission, property is held or may be used under an employee benefit scheme. At the time the option is granted, that being the thing in respect of which the deduction is otherwise allowable, at the time the option is granted, no new property comes to be held by the EBT trustees. They have shares already, and those shares that they have already are already held or may be used under an employee benefit scheme, looking at the language of 1291 1A. And those shares which they already have, those shares which are already held or may be used under an EBS, continue to be held or may be used under an EBS. So there is no act or omission leading to a change in the status quo ante. Nothing changes in relation to the shares. They were already held under an EBS, and they continue to be held under an EBS. They were capable of being used under an EBS. They continue to be capable of being used under an EBS. So I say that the shares, for those two reasons, are just irrelevant. What about the grant of the option? So it's common ground that the debit is in respect to the grant of the option. And the real question is, looking at section 1291, is there an employee benefit contribution? I've already made my points about the proposition for which my learned friend contends being a powerfully counterintuitive one. I'm not going to repeat those points. And I don't have a simple knockout blow on the option. I don't want to pretend that the matter is straightforward as a matter of statutory language. It isn't. So I say, nevertheless, as a matter of statutory language, I'm right, and I'll come on to that in a second as to why I say that. But I also want just to point to a couple of indications in the language used by the drafter in that sub-chapter that indicate that the drafter doesn't intend the provisions to apply to a direct award of remuneration. as the lady pointed out yesterday, the option is an incentive. It incentivises the employees even before it's exercised. It is a benefit when it is granted. So, what indications do I refer to that the drafter doesn't intend the subchapter to apply to transactions like this? Well, the title of the chapter part which you see at the bottom of electronic file 369, employee benefit contributions. The title of the section 1290, employee benefit contributions. And the term that is being defined, employee benefit contributions, are all indications that you're concerned with something other than a direct award. You're concerned with something other than a transaction of the type that is caught by section 1289, 1288.
By a direct award, you mean a straightforward payment of salary? Or what do you mean?
By a direct award, I mean remuneration in the sense in which that term is used in section 1288. So, if an employer gives something to the employee which has value, clearly you fall within section 1288. And the points that I'm... and that's the language, that's what I mean when I talk about a direct award. I mean something given by the employer directly to the employee without any intermediary being involved. And the points that I'm making by reference to the subchapter in which 1290 and following appear is that the drafter in 1290 and following has in mind the situation that confronted the House of Lords in Dextra, the paradigm case, as my Lord Briggs put it yesterday, of a payment into an EBT, not in contradistinction to a direct award. So lots and lots of indications in the subchapter that that is what the drafter is looking at.
And within all that, the option, insofar as it's property, is hardly property in the hands of the EBT. The EBT is the obligor under the option.
Yes.
If it's property in the hands of anybody, it's from first to last property in the hands of the employee. I mean, that's what underlies your point, that this is something given directly.
Yes. Well, I was going to come to that, having pointed to some... No, well, my Lord's point is absolutely right. The option is anterior to the scheme. It's something that sits. It's property that comes to be owned by the employees in consequence of what I've been calling a direct award. And so it's not a contribution which is made to the scheme.
What is not a contribution?
The option. The option is not a contribution which is, quote unquote, made to the scheme. You see that word made in section 1291 and section 1291(1). And it's also not property which is held or used under a scheme, the point my Lord Briggs was putting to me a second ago. And that's the basis upon which the first tier tribunal at paragraph 98, EF 202, found in my favour. And the Upper
Why do you
Tribunal
say
agrees.
it's not a contribution made to the scheme? Because it's made by the scheme to the employee?
Because it's made by the employer to the employee. There's no scheme involved.
But who is the counterparty to the option?
Well, it's the EBT trustees grant it to the employee at the direction, de facto, although not as a matter of law, of the holding company. But that's not a contribution, I say, which is made to the scheme.
What about or may be used? I'm looking at 1291 1A, which I think Mr. Ghosh relied.
Well, it may be used is a provision that looks to future uses of property.
Yes.
But the option is extant when it is granted. So I say that may be used is inapt to deal with the option. The option isn't an option that may be used under the scheme.
Because it only comes into existence really when it's granted.
Because it emerges fully formed when it's granted. Nothing else needs to happen to it.
But it only turns into anything concrete if it's exercised,
In my respectful submission,
even though it's a value from the outset.
well, one of the ways in which you crystallise the value of an option is by exercising it. Another way is by selling it. But
Are these options transferable?
you have to. I don't know.
I'm inclined to doubt it, but I don't know.
Yeah, I'm also inclined
I'll
to
see
doubt
what
it.
the incentive would be if you could flog it the next day.
But the point is, you have to consider. You're considering whether the debit is disallowed in year one. You also must be considering whether the debits that arise in years 2 and 3 and 4 are disallowed. You have debits arising in subsequent years as well. That was the point that I was making earlier about the debit not being capable of being described as consumed immediately on receipt of the grant of the share option. And if you look at my written case, you'll see some discomfort with the proposition that the debit can be said to arise in respect of the grant of the share option at all. What I say in the case is that the better analysis is that the debit arises on the consumption of the services of the employees in all of the years until the vesting of the option. You have findings of fact in the FTT that the debits arise in years 2, 3 and 4, not just in year 1. And it's quite difficult to see how the debits arising in years 2, 3 and 4 arise in respect of the grant of the option. The grant of the option is a condition precedent to those debits arising, but really they're arising in respect of the continued service of the employees. The other indications that I was going to rely on, I mean, it is relevant, I say, that 1291(1)(b), which, as is common ground, does not apply to this transaction, talks about an increase in the total value of property that is being held. It gives you a flavour of what the drafter is contemplating when the drafter is defining an EBC. Property coming to be held under an arrangement, or the property that is held under the arrangement having value flow into it through one of those clever tax lawyer wheezes.
Does it convey the sort of impression, I'm not sure one could put it higher than that maybe used doesn't mean by the employee, it means by whoever's running the scheme, so that it's held or maybe used, it says, or so used under an employee benefit scheme. But if the thing's in the hands of the employee and he can do what he likes with it, the scheme isn't thereafter involved in its use at all.
Yes.
Save in this case that the scheme is arguably the obligor.
Well,
the fall guy, if the option is exercised, it has to provide the shares.
That's ultimately where the FTT and the Upper Tribunal got to.
Yeah.
I mean, I've been quite careful, at least I've tried to be careful not to overstate my case on the point. The language is not such as to enable me to submit to the Supreme Court that there is a clear knockout answer, and that's why I laboriously took you through the exercise of seeking to discern whether it can really have been Parliament's intention to deny, in the face of Section 1289 4B, a corporation tax deduction in respect of exempt income, whether it can really have been Parliament's intention to do that really quite important thing to the Corporation Tax Code through the mechanic of Section 1290. I mean,
it occurs to me that the word contribution may also be significant. It's a different word from, say, payment or transfer. Contribution is something which goes towards, well, typically a fund, or it may be, I mean, it could be a charitable fund, it could be a retirement gift collection, but some sort of larger accumulation of contributions, if you like.
And that was the point, my lord, that I was seeking to make when I showed you the title of the chapter, the title of the section, and the term that is being defined. I entirely agree with what my lord puts to me.
And here it's called an employee benefit contribution, and the contribution is made if, as a result of something that's done or omitted to be done, property is held or may be used under a trust, a scheme, or some other arrangement for the benefit of employees, read short.
Yes. One can also look at sections 1293 2A, which contemplates a scheme manager and a transfer of an asset to a scheme manager, and section 1294 sub 1, which talks about payments out of the scheme. And so again, I come to the
Yes,
distinction that I'm seeking to... Sorry, my Lord.
I'm sorry, I'm just looking online for a dictionary definition, and the one from Oxford Languages is a gift or payment to a common fund or collection. Let's see, which is pretty much what I was trying to say.
Well, that does very much connote the essential submission that I'm making, which is 1290 and following is intended to deal, as my learned friend's written case says, with the situation with which the special commissioners and then all courts up to the House of Lords were confronted in Dextra, where you have a payment to a common fund and then a payment out of the common fund, and in contradistinction to the world contemplated by the drafter in section 1288, where you have what I put, without initially defining it, a direct award to an employee. I've never sat as a judge, but I have a sense that this might be one of those situations where you listen to all of the submissions and then you go away and you work out for yourselves what the answer is by reference to statutory language, and the submissions as they develop aren't enormously helpful to you. That is, I think, what each of the courts below did. First tier, in my respectful submission, the treatment of the first tier is the best treatment. Adopted by the upper tribunal. The Court of Appeal understood wrongly my learned friend not to be pursuing a point about the EBS being the grant of the options and deals with shares. In my respectful submission, there is no argument about shares. The answer in relation to shares is clear. The point in relation to options is more difficult. And ultimately, there is enough, I say, in the statute to get to wherever you want to get to. Ultimately, the question for you is a question of parliamentary intention. Can Parliament have intended this radical shift in the corporation tax code with this mechanic? Answer in my respectful submission, no. To say that you never get a CT deduction in the case of exempt income, and my learned friend came very close to saying that yesterday, is a radical shift in the corporation tax code. And as the first tier and the upper tier both held, without regard to 1289, if Parliament had wanted to do it, it couldn't have done it by this mechanic. That proposition was put to my learned friend yesterday. A learned friend said, there's not much I can say to the proposition that Parliament could have done what I say it has done by a simpler means. Unless there's anything further with which I can assist, those are my submissions.
Mr. Gosh relied particularly on paragraph 20 of the judgment in Dextra as making it clear that it was envisaged that you might never get the deduction. My question is that distinguishable from this case? Because in Dextra, there were potential emoluments in the fund which might never get into the hands of the employees at all. And if they didn't, then they're not deductible. But here, the emolument is the option rather than the share. It's that which one hopes incentivises the employees. So there isn't that time lag, as it were, between the debit and the emolument in the form of the option. So here one would be, if one took that paragraph from Dextra, one would be applying it to make a different point, which is not the point that was made there, namely, you don't get the deduction if you actually never pay the emolument to the employee, but saying you don't get the deduction even if you do pay the emolument in the form of the option to the employee, if the option is never converted into a share. And that's a rather different thing.
Milady, I would give a simpler answer to Milady's question, which is this. Paragraph 20 is concerned with a situation in which normal income, I use the word normal in contradistinction to exempt income, is paid into an EBT, and it may be paid out of the EBT in a form that gives rise to an income tax charge, a NICS charge. And if it is, then it is, then it leads to a corporation tax deduction, or putting it more accurately, it releases the corporation tax deduction. And if it isn't, there is no corporation tax deduction. So that is exactly what, in my respectful submission, Parliament was seeking to achieve. The distinction between that case and my case is that you cannot grant exempt income in a form that leads to an income tax charge or a national insurance contribution charge, because it is exempt income. So there is no world in which I get a corporation tax deduction in respect of the grant of exempt income if my learned friend is right, because it will never come out of the EBS in a taxable form. And until it comes out of the EBS in a taxable form, I don't get my corporation tax deduction. So the mischief that Parliament is addressing in 1288 and 1290 is a world in which you create, through clever tax lawyer mechanics, an asymmetry, the asymmetry being in respect of normal income, you've achieved a corporation tax deduction without a matching income tax charge. And what the drafter is saying is that is bad, and I'm going to stop you from getting that asymmetry. But there's nothing bad about an asymmetry that arises because the income that you've been awarded is exempt income. That's not bad, that's good, because Parliament has said there is no income tax charge in respect of this exempt income. That is Parliament's intention. So paragraph 20, I say, doesn't help me, but it doesn't hinder my argument either. It's dealing with, well, it's dealing with the sin that Parliament is trying to address in these provisions. The sin being the creation of an asymmetry in respect of normal as opposed to exempt income.
Because it's exempt both when it's granted as an option and when it's converted into a share. Or I thought HMRC, I may misremembered this, that they accepted that there would be a deduction as and when the options were converted into shares.
As a matter of, there is a statutory provision that in a chapter that concludes with section 1038A that says that if you are granted an option and you exercise that option, you get a corporation tax deduction. It's a specific statutory regime that was introduced in 2003 from memory. But it's a so what point, in my respectful submission, because this is not a debit that arises under that statutory scheme. It's a debit that does arise in respect of the grant of income that is exempt. And so the fact that you're specifically given a CT debit, a corporation tax debit, under a specific statutory regime, doesn't help you answer the point that arises in this case. I mean, I don't get my debit if I grant another share option today. That's what section 1038A says. 1038A says the accounting debit that arises is disallowed with effect from whenever 1038A comes into force. So this case is concerned with a historical world. But my point, which is that there is no wrong in the arising in consequence of exempt income being granted in a form that leads to a corporation tax deduction.
I understand your point about the rights and wrongs of it, but there's no doubt, is there, that if an employee, if an employee benefit contribution is made by an employer in the form of money into an EBT, which is later paid out as exempt income, you can't deduct.
Well, it can't be paid out.
That's one of the other examples in 1290. B, C, or D applies in 1292. One is then set out in the rest of 1292, because it just wouldn't be a qualifying benefit.
Well, I'm struggling to imagine a world in which cash comes out of an EBS in an exempt form. I mean, the circumstances in which Parliament exempts income from liability to income tax and or national insurance contributions are very narrow for obvious reasons.
I suppose what I'm asking is, why then is condition A expressed in the term it is in 1292 2? It's intended to mean that if conditions B, C, or D don't apply, which one might say are slightly special, well, then unless when the payment or transfer comes out it gives rise to income tax or an NIC charge, then it's not deductible when it goes in.
Certainly, 1292 2 is one of the circumstances that releases a corporation tax deduction. And there are other circumstances as well. And if one of those circumstances obtained here, we wouldn't be before you. But my point remains, which is that there is, and generally speaking, the release of cash from an EBS, generally speaking, if not always, the release of cash from an EBS will be in a taxable form. And what Condition A is directed at is the normal circumstance of the type contemplated by Lord Hoffman in Dextra. That's right.
Yeah.
But because the mischief that the provisions are aimed at is a mischief of creating an asymmetry in respect of normal income in contradistinction to exempt income. There is no mischief.
There's been a policy that leads to the income being exempt. In other words, to encourage employers to to set up schemes to incentivize performance would be undone if the employer couldn't deduct the contributions that were made into the scheme.
Well, that's
it'd be an incoherent policy.
My Lord, that's absolutely right. And it's another, if I might say, a helpful way of articulating my point, which is that if Parliament wanted to do it, it would have done it in very clear language, not through this mechanic. But I mean, I entirely take my Lord Briggs's point that when money comes out in a normal taxable form, the symmetry is restored, and so you get your corporation tax deduction.
It comes out in an exempt form. There isn't any asymmetry, which, on your analysis of what this is all about, these sections are designed to cure.
Quite so.
Yeah. Thank you.
My Lord,
it rather looks as though there are no more questions for you, Mr. Morm. Thank you very much. Mr. Ghosh.
I'm grateful. Please, may I make my reply in a series of points. One, and I'll start with 1290, with your permission. One, just to be clear, in answer to my Lord Briggs's question, it's the acquisition of an option that is exempt income. That's section 475 of ITPA on page 458 of the electronic bundle, and that falls into the definition of exempt income under section 8, which is 354. Tapping into an observation and a question asked by my Lady Rose, on the exercise or any other dealing of that option, that is not exempt, and that could give rise to a qualifying taxable benefit. So it's not a once and for all lost CT deduction if 1290 applies. That's simply wrong to say that. Two, dealing with an observation made by my Lord Reid. Would this be an incoherent policy to grant a CT deduction under 1288, but then defer it, not take it away, defer it under 1290? My respectful submission is no. 1290 was enacted in response to losing litigation, and it may well be, not incoherent, a new parliamentary policy. Parliament's changed her mind as to when a deduction is available. That's parliamentary sovereignty. There's nothing incoherent about it. Three, in response to an observation made yesterday by my Lord Reid, well, what are you saying? That do these provisions apply to your contractual rights to get salary, like many anti-avoidance provisions, both 1288 and 1290 will apply to everyday circumstances with no practical effect, because the provision will be if it's earlier than the actual payment, and the payment date for a weekly or monthly salary will happen very shortly after. That's not a point. To be clear, it is the grant of the option to which the respondent companies are not parties which generates the debit. And if that's the arrangement, you have an act, the grant, as a result of which property, the option rights, are held under, and if you're thinking about the dictionary, it's the Oxford Dictionary that says under means within or covered by that arrangement. And the distraction about talking about shares is under that arrangement, you may newly have property, because that option's been granted, shares which might not have been needed for the satisfaction of that option may be needed, and thus may be used under that arrangement. And that's true whether the shares are held already or need to be acquired. So, may I respectfully ask the court to record these submissions carefully, because when we read your judgment, we need at least to know that our position is there's no incoherence of, in policy, and the property we're talking about, be it the option rights or be it the shares, fall very readily within the text of section 1291. And it would be wrong, therefore, to confine the words act or omission, new words inserted in 2008, confine their meaning by reference to the word contribution. The whole point in OCO, which is at tab 20, page 744, I think, anyway, it's tab 20, was that there wasn't a payment or transfer of assets to a fund. It was a declaration of trust over a company's own assets. Here, as it happens, the option was granted by the EBT trustee with the shares from the parent. So to say this was a direct benefit from the respondent employer companies is also simply wrong. So I don't accept that there's any textual difficulty. Those difficulties are all with my learned friend. Neither do I accept there's any difficulty in policy, and neither do I accept that the result is an odd one, given that they will get this deduction if and when the option is exercised or otherwise dealt with, because that isn't exempt. And to be clear, the Part 12 deduction, this other statutory deduction, is an additional deduction. That's the problem. There's a double deduction if 1290 doesn't apply, none of which could have been contemplated as being what Parliament wanted. No one will be surprised if 1290 defers this deduction until and unless the options are exercised, and then they get a double deduction if it's exercised. Still, today, that's incoherent. Now, on section 1288, I've already said why Parliament changed her mind as to what she thought about the time for a deferral of a deduction. The effect of what my learned friend is asking you to do is to write into subsection 4 of 1290 a new exclusion. The contortions, I'm saying this respectfully, that you'd have to go through to change the text of 1290 from what it says to what you'd like it to mean. I don't mean you. You'd only want to do all that if you thought it was giving the wrong answer. And the last point I want to make about 1290 is that, like all anti-avoidance provisions, and nobody's saying this is a tax avoidance case, but it's got an objective. The observation that what we're looking at is not the paradigm case, that's whenever you've got an odd answer, like a double deduction in this case, the courts are forever being faced with a transaction or a series of events that isn't the paradigm case. The question is, does it fall within the text and the objective and the purpose of these provisions? And in my respectful submission, the answer to all of those is yes. And they will get, as I keep saying, a double deduction if and when these options are exercised. It's not a once and for all. The point about Dextra and paragraph 20 is that even if it is because the options have never been exercised, that is something which Lord Hoffman accepts that Parliament says one may have to live with. So there it is, I've said it. No one would be surprised if 1290 applies. It's the opposite. Moving on, please, to the accounting. As I've said, it's the grant of the option that generates the debit, even in the absence of a recharge. Over and over again, my learned friend has relied on the recharge. And I know that's the case that this court has got. But please may the court record that the debit arises even though there's no recharge. Now, I wonder if I could leave the court with a reminder of what this case is about. Please may I ask the court to look at it's in the core bundle. It's the electronic bundle, page 180. And if you please just remind yourselves that IFRS 2 accepts, and for the moment forget the recharge. There's no cost to the issuing entity, and therefore there shouldn't be an expense. The drafter said, we hear what you say, but we'll book an expense anyway. And if you hold that thought, that it's the grant of the option that generates the debit even without a recharge, please may you, may the court turn to paragraph 31 of the FTT decision, page 183. Now, this is dealing with, and my Lord Briggs made a very telling observation yesterday. He said, oh, these are just sweeping up. And the exchange I'd had earlier in that day with my Lady Rose was, well, no, these are critical. Because if you look, please, at paragraph 31, the corresponding credit was a capital contribution. Why? It's at paragraph 32. And I think my Lord Sales was saying, well, of course, this transaction's got to be sensibly recorded for both parent and subsidiary. The rationale for this was that by issuing share options to employees of the subsidiary, a parent company was providing a benefit to its subsidiary and was in substance making an investment in its subsidiary. It's not an accounting fiction. It's not this credit capital contribution, something that, oh, well, why is it even there if you're paying for it? It's because the issue of the option is upping the value of the subsidiary. Why is that important? It's because, and this is at paragraph 35 on page 184, the recharge was not touching the debit. That was consumed on receipt, and it's not like, my Lord Reid said, well, you can be funded by capital and use that money to pay the wages. Absolutely. You could be funded with cash, which sits in your balance sheet, and then there's a separate double entry when you use that money on wages. Here, it's a phrase I said to you over and over again yesterday, but I wasn't making it up. It was in the explanation of IFRS 2, which I showed you. It's because the receipt, this benefit of the capital contribution was consumed on receipt. And by the way, yes, that debit was spread over the vesting period. That's normal. That's paragraph 28.3. That's all that was. It's not saying that, oh, you're consuming employee benefits. It's nothing to do with the options. That's where the debit is from. That's misleading. The debit was initially calculated, that's what 28.3 says, and then spread over the vesting period. Now that's relevant. Why? And I'll, well, for all sorts of reasons, including the clock, take my reply to the accounting submission short. First of all, on the tailpiece of section 46, absolutely, what your lordships and my lady are going to be deciding is who has the last say in computing CT profits. Is it, and actually this was the way that my learned friend put it, is the computation of taxable profits ultimately a rule of law, or is it now exclusively, to the extent you've got accounting standards, a matter of accounting expert evidence? That's the stakes in the answer that this court comes to. And just about that, I'm not going to take you to it, I don't have time, but the passage from Lord Bingham I showed this court yesterday, where he left room, the learned Lord Bingham left room if the accounts didn't show the true facts. The golden rule that was replicated in William Grant. It was in the light of having read out the Vice-Chancellor's passages in Odeon that Sir Thomas Bingham said, look, in a world where the accounts aren't showing the true facts or they're otherwise inapt, if you can't show me that, I'm going to stick with the accounts. That's what I'm doing here in that case, in Gallagher and Jones. So the analytical basis for leaving room is because your task, our task, is to compute profits. If the accounts don't do that, you shouldn't be looking at them. Or, put another way, the codification of the case law includes the codification of Gallagher and Jones. And my Lord Reid read to me several times the passages in William Grant, by my Lord Hoffman, and my Lord Hope. They're not statutes. They were saying, looking at what we've got here, these accounts are computing profits. Stick with those unless you're telling us not. There's something that says we shouldn't. And the explanatory notes, including section 42, even that left room at paragraph 5 of the explanatory note. Please, I respectfully might ask the court to record that. It says, we only depart from the accounts in exceptional circumstances. And the tailpiece is recorded as, for example, preserving the principle that profits and losses can't be anticipated. That's not in the statute anywhere. That's case law. That's what was replicated, this thinking, in the codification of Sharkey and Werner. Because if, in fact, gap, which meant you shouldn't have had a market value imputation, Sharkey and Werner was reversed. If that was right, everybody would be getting it wrong for 10 years. And there are cases in those 10 years, Petrotim and Ayers is one, which absolutely applied Sharkey and Werner. and I'm going to deal very short with what I'm going to call my daddy point. The proposition that, well, yesterday I can't book a deduction from my suit because I only wear it in court. But tomorrow, well, actually, we've had a consolidation. I'm going to have another go. That proposition, for the reasons given by my lady, Lady Arden, in Derry, endorsed by the whole court, including by my Lord Reid, is, I say this very respectfully, please, a silly proposition. And just by the way, Lowry wasn't through with accounts. Lowry was construing the words laid out or expended, which morphed into incurred. You've got my submissions about why I think Lady Arden, I say this respectfully, got it completely right. But the notion that on every consolidation, and this is what the Court of Appeal said, it's not even a question of stare decisis. You can't even look at the pre-consolidation case law. That proposition, and that matters, not to this court, but it matters to every single other person who has to apply the tax code, courts below and us, taxpayers. We need to know the answer. I say the answer is the Derry answer. Of course, pre-consolidation case law survives consolidation. The Court of Appeal went stronger. They said you can't even look at it. On incurred,
I doubt whether we even addressed on it in whatever the case was, where Lord Carnwath
Derry.
said that we should read what Lord Sales had said in an earlier case along with what Lady Arden said.
Can I take this short, because I've got to be able to reply on my other points?
Because there's a real danger of paying too much attention to casual comments in judgments.
My Lord, can I say this quickly? Paragraph 10 of Derry was not a casual comment. It was expressly endorsing Lady Arden. And we have to rely on it because we read that, all of us. So it's not a game where we can say, well, that was casual. While I was there, I remember that.
Well, judges are human beings. They make mistakes. We don't always notice every nuance of a judgment when we're concurring in it.
Well, my Lord, may I leave this point simply by saying it was an express endorsement by the whole court of paragraphs 84 onwards. Going on to incurred.
Terry.
You can't look at the recharge. Why? Because in that passage I showed you from the FTT, you can't have it both ways, looking at the accounts for the debit but not looking at the accounts for the recharge. The recharge was a repayment of the capital contribution. In other words, a repayment of the benefit by the parent through the EBT, granting an option. The debit was untouched. And that's why the recharge can't inform the question of whether the debit, because if you remember, Section 48 doesn't confer tax relief. Section 48 says, and all it says, is where you read the word expense, you plug in the word debit. So I'm now doing what even my Lord Reid tells me I should do, which is plug that word into the tax code. Section 48 doesn't confer tax relief. Section 48 tells me a definition. Section 54 says the expense, bracket, meaning debit, close bracket, has to be incurred. What's been incurred? If there's no recharge, nothing. I mean, literally. If there's a recharge, not the debit, that's common ground. And that's why it also informs the purpose question. Because and this was a point that actually was addressed by my Lord Briggs. The capital contribution was repaid. That's what I'm saying, can't have it both ways. I'll look at the accounts for the debit, but I'm not going to look at it on the credit side or for the recharge. It was doing what? It was repaying parent co of an amount equal to the benefit granted on the grant of the option. Nothing to do with consuming employees' services. I mean, literally nothing. And that's why it also informs it being that capital contribution matched by the debit because the benefit was consumed on receipt. It also informs capital. We absolutely mustn't forget the capital point or dismiss it. It's critical because the only reason this debit exists is because Parent Co granted the option. It doesn't exist because the respondent companies are consuming employee services. And just about that, of course, in response to my lady's point about P&L debits, including capital nature, I mean, depreciation, that's obvious, that was mentioned in William Grant. Or if I trade and I've bought my building for 100 and I sell it for 10, that 90 goes to P&L. So there isn't a world.
So you're saying that the fact that it's required to be recorded in P&L doesn't tell us that it's a revenue rather than a capital expense?
Absolutely, absolutely. Yes, I am saying that, and no, it doesn't, my lady. Now, just like yesterday, I didn't want to work myself up into anti-IFRS 2 rage. I don't want to work myself up into anti-paragraph 10 of Derry rage. But I do, please, leave this court with this observation. It's not a game. This tax code does what? It produces a number where a taxpayer's got to find money. It's a monetary liability to pay HMRC. That's the point of Section 34 in computing taxable profits. That's what tax is. And accounting standards are a good surrogate for computing that in the light of authorities, especially coming from this court for blinding the obvious reasons. That's the law. If you please give me 1 minute. Oh yeah, you brought it up again today, my learned friend, in an exchange with Lord Reid. The provisions, just like they did when they were brought in 1998 in Section 46 that said we don't need money. Do you remember Section 46 says that irrespective of cash receipts, and that's replicated in Section 46 and 48. That's dealing with, I said this yesterday, but I should add it, that's dealing with provisions and accruals. But all of those reflect actual payments to come. That's what a provision is. That's what an accrual is, whether of a receipt or a payment. And every single case in that bundle that this court has got is to do with a provision or an accrual or costs which, even if they're not it's not a cash basis, is reflecting something I'm going to pay. So when my learned friend said a provision is something where there's no certainty of that money being paid, that I say this respectfully, that's nonsense. A provision can only be booked, a specific provision, because you've got a liability. That's what Jenner's was all about. And learned friend shakes his head. You can shake it all you like. So that's what a provision is. A general provision is different. That's like 2% of all debt, something of that nature. If the court reads Jenner's, they were going to pay that money 2 years. In Britannia, they were going to pay that money to repair the aeroplanes. Yes, otherwise the provision gets released if they don't pay that money. Actually, that is important. I'm sorry. That is important. If the money actually isn't paid, the provision is released and there's a profit. I'm very sorry. That's a good point. But that shows it's all to do with something real. Can I sit down now? Those are my submissions.
Very well. We'll consider the submissions and let you have our judgment in due course. The court will adjourn.